This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court's conservative majority signaled it's likely to deal another blow to LGBTQ rights by upholding state laws barring transgender girls and women from playing on female school athletic teams. Conservative justices like Samuel Alito and Brett Kavanaugh directed skeptical questions at the lawyers for the transgender athletes who are challenging laws in Idaho and West Virginia as violating the Constitution and Title IX.
There are an awful lot of female athletes who are strongly opposed to participation by trans athletes in competitions with them. What do you say about them? Are they bigots? Are they deluded in thinking that they are subjected to unfair competition?
I mean, I hate that a kid who wants to play sports might not be able to play sports. Hate that. But it's kind of a zero-sum game for a lot of teams. Someone who tries out and makes it, who is a transgender girl, will bump from the starting lineup, from playing time, from the team, from the all-league, and those things matter to people big time, will bump someone else.
The court has repeatedly ruled against transgender rights in recent years, upholding a state's ban on gender-affirming care for transgender youth and allowing President Trump to kick transgender people out of the military and to block passport sex markers that align with gender identity. In light of what seems like an inevitable decision, several justices, including Kavanaugh, repeatedly asked whether a decision in favor of the state bans on transgender athletes would have any effect on challenges to state laws that permit transgender athletes to participate on female teams.
And those states who do allow it, is your position that they are violating the Constitution, the Equal Protection Clause, rights of biological girls and women by allowing that? Or do you say that's up to each state to decide and that the Constitution gives discretion to the state whether to allow it or not to allow it?
My guest is David Cole, a professor at Georgetown Law and the former national legal director of the ACLU. David, let's start with the big question. After listening to these oral arguments, does it seem like the justices are going to uphold these state laws that ban transgender athletes?
Well, I think the pretty broad consensus of those who listen to the arguments is that they will uphold these laws. I think going in, that was also the broad consensus. And I don't think the arguments really changed that assessment. I think they showed the justices, dealing seriously with the implications of how they rule. But I would be surprised if they don't uphold the laws.
What legal question do you think the decision will turn on? I mean, there were all kinds of questions about the difference between boys and girls on the basis of sex and where the science is. I mean, what do you think it will turn on?
Well, that's the rub. There are many different ways that the court could resolve these cases, including by declaring that actually, because there's a lot of uncertainty and a lot of competing scientific evidence that the states have sought to sort of insert into the record after the district court proceedings were over through amicus briefs and by citing to, public reports and the like, those have not been tested. And so to the extent that the resolution of the case requires a decision about the factual question of to what extent do transgender athletes who have taken puberty blockers or hormone therapy still have some sort of sex-based advantage over cisgender women, that's really something that ought to be sent back to the lower courts, not something that this court should be deciding, because most of the evidence that the states are relying on post-dates the trial and the hearings that were involved in these cases.
There was a lot of discussion about athletics being different and about the Javits Amendment. Tell us about the questions that were raised.
So there are two legal questions in the cases. One is whether excluding a transgender woman from the women's team violates Title IX of the Civil Rights Act, which requires institutions that receive federal funding not to discriminate on the basis of sex. But the Javits Amendment recognized that sports are different in general, and that therefore there can be men's and women's teams. You can have, certain sports have only a men's team, like football often. Other sports can have only a women's team. Sometimes schools have only a women's volleyball team or only a women's cross-country team or what have you. As long as the overall opportunities are equally available to all, that Congress said was permissible. So under Title IX, Congress sort of blessed sex segregation of sports as not constituting sex discrimination in general, as long as equal opportunities are provided to all. But what this case presents is what happens when you've got a situation where a trans woman is denied the ability to participate in women's sports because she was identified male at birth and can't participate on the men's team either without denying who she is. That's a serious harm, and that might well constitute discrimination under Title IX. That's the argument. And then there's a separate legal question in the cases, which is whether under the Equal Protection Clause, as a constitutional matter, is it constitutional to divide up teams by sex and then to exclude trans women from the women's team? And on that issue, again, sports might be different in the sense that the court might say, well, there are real differences between men and women that justify having separate women's and men's teams in general. And indeed, the challengers don't dispute that. Yes, of course, you can have men's and women's teams, but as applied to transgender women who have eliminated any sex-based advantage that they might have by virtue of being biologically male, by taking puberty blockers, by taking hormone therapy, by reducing their testosterone levels to the average level that women have. At that point, it's not clear that the state's interest in having a separate women's team justifies keeping that person off of the women's team because she has eliminated any sex-based advantage that she would have. And it's only that category that the plaintiffs are arguing have a constitutional right to participate. Not all transgender women, but only those who can demonstrate that they actually don't have any sex-based advantage, that they are similarly situated to the other women on the women's team.
It seemed to me like the intent of the three liberal justices, mindful of the trend of rulings against transgender rights, that their intent was to try to marshal support for a very narrow decision.
Well, I think there certainly is concern that this decision not preclude or pretermit challenges to other kinds of laws that treat trans people differently. I think you got some of that concern, not just from the liberal justices, but from some of the conservative justices as well. Justice Kavanaugh, expressed concern. Well, what about the blue states? About half the states permit trans women to participate in women's sports. And some have argued that that's unconstitutional, that violates Title IX, that you can only do it one way. And he seemed to be concerned about the implications of this case for that kind of policy. He seemed to want to leave it to the legislatures of the states. And if they want to allow trans women, fine. If they don't, that would be fine too. Whereas the Trump administration has taken the position trans women should basically not exist, but they certainly should not be participating in women's sports. And it is illegal for a state to even permit trans women to participate, even where those women have no sex-based advantage because they've eliminated those advantages. So I think they're thinking about those consequences.
So the Bostock case was the last time that transgender advocates won at the Supreme Court, but the Chief Justice was quick to say this isn't that case. He said the question here is whether or not a sex-based classification is necessarily a transgender classification. How far are the justices stepping back from the Bostock case?
They haven't stepped back from the Bostock case yet. I mean, what the Bostock case said was that when, in the employment context, when an employer fires someone because they are transgender, that is sex discrimination. That treating someone differently because of their sex assigned at birth and their gender presentation is a form of sex discrimination. I think in this case, they're not going to have to address Bostock because the state argues we're not actually targeting trans people in any formal way. We're not saying, as the employer did in the Bostock case, I won't hire any trans person. What we are saying is that we are dividing up the teams by birth sex. So those people who were designated male at birth are on the men's team. Those people who are designated female at birth are on the women's team. And we exclude from the women's team anyone who was designated male at birth, whether today they present as a man and are what we call a cisgender man, or whether today they present as a woman and are what we call a transgender woman. And so the state's argument is that they're not actually discriminating on the basis of trans status itself. Now, we all know, of course, this was driven by trans women athletes in particular, and by a whole set of assumptions about trans women athletes that are not true as to many trans women athletes, that they have this extraordinary advantage over other women. Some do. But the case was brought by those who, through medical intervention, have ensured that they do not have any sex-based advantage. And as to them, the question is, if the state's justification for denying you participation on the team because of your sex assigned at birth, is that permissible when their interests are not furthered by excluding you? Their interests are in making sure that the women's team does not get overrun by people who have a sex-based advantage. But those transgender women who have eliminated their sex-based advantage through the medical intervention and the like, they don't pose that threat. They don't undermine the fairness or the safety of women's sports.
In more than 3 hours of oral arguments, it seemed like there were a lot of balls in the air. Do you have any idea what they might focus on in the decision?
You know, if I had to guess, I would say they know, the destination, but they're not sure on the route. And if they are going to rule against the transgender women here, I think it's important that they do so in ways that leave open for future litigation a whole host of other kinds of questions that don't involve sports, don't involve this one area where you do actually have a long history of separation based on generalizable physical differences. The same kinds of arguments about fairness and the like don't apply to bathrooms and don't apply to excluding trans people from all kinds of activities in life. And so, I think it's important that the court not decide too much, because I think in the long run, we're going to recognize trans people are people. They deserve equal dignity. We should not be treating them as categorically as somehow an illegitimate class. And we need judicial protection to ensure that they have equal protection under the law, precisely because they are a small minority, one that has faced a lot of discrimination over history. And the court should not write itself out of that task. It's an ongoing task, I think, but it's part of the court's responsibility is to protect those who can't protect themselves from the majority. And boy, trans folks are, squarely in the middle of that category.
It'll be interesting to see what direction they take in their opinion. Thanks for joining me again, David. That's Professor David Cole of Georgetown Law. Coming up next on the Bloomberg Law Show, Louisiana faces off against big oil at the Supreme Court with billions on the line. I'm June Grasso, and you're listening to Bloomberg.
We now know, having gone to trial with Chevron down in Point Lahash, that they do not dispute that they dumped billions of gallons of produced water from oil wells directly into our marsh, both before and after 1980. That's why this is such a massive deal for the state of Louisiana.
That was Louisiana Solicitor General J. Benjamin Aguinaga arguing at the Supreme Court in a case where repair of his state's wetlands, which have been called one of the most critically threatened environments in the United States, is at stake and potentially billions of dollars. Back in 2013, 6 Louisiana parishes filed 42 nearly identical lawsuits against Chevron, Exxon, and other oil and gas companies, accusing them of violating a state law and demanding that they repair severe damage to the state's coastline from decades of oil and gas production. And last April, in the only case to go to trial so far, a jury in state court ordered Chevron to pay $745 million toward restoring the coastal region. Now, Chevron and the other companies are asking the Supreme Court to move the cases from state court to federal court, which is often seen as a venue friendlier to corporate interests. Chief Justice John Roberts and Justice Neil Gorsuch expressed concerns about the ripple effects of allowing such a move.
Well, you're right, obviously, that relating to is very broad, but it's hard to see where you stop. I mean, is it a butterfly effect? You know, the butterfly flaps its wings and it has the end result halfway around the world?
The Big Bang is related to you being here today, counsel, right?
The ultra-conservative Fifth Circuit had ruled that the cases belong in state court. Joining me is an expert in environmental law, Pat Parenteau, a professor at the Vermont Law Graduate School. Pat, give us the background on these lawsuits.
So this has to do with Louisiana's continuing loss of coastal wetlands. You know, it's the largest loss of wetlands in the nation, and it's causing all kinds of horrific problems for the communities on the coast of Louisiana. The floods, the storms, the loss of fisheries. Much of it relates to the oil and gas activities in extracting oil and gas from the Gulf of Mexico. And, you know, I've been down there. I've seen the damage that's being done from the oil and gas activities. It's complicated, but one of the major reasons for the loss of wetlands is the discharge of really toxic, polluted water, processed water from the oil and gas extraction activities, both on land and offshore, by the way, and also building these canals to move these great big rigs in and out of the Gulf. And all of this erodes the wetlands. It contaminates them. It causes the vegetation to die. And when the vegetation dies, the wetlands die. All of this has been going on for decades. All of this has been well understood and researched for that period of time. The oil companies, they've been told that they're causing this damage by the state of Louisiana in violation of the state of Louisiana's permit programs for oil and gas activities, in violation of the state's laws requiring restoration of wetlands that have been damaged, causing billions of dollars worth of damage. And so finally, the parishes of Louisiana, which are counties everywhere else in the country, have had enough. I mean, you know, they've had this uneasy relationship with oil and gas activity, which creates jobs, brings money into the communities, but it's destroying their way of life. So they go to court in Louisiana, and they finally got a major jury verdict, over $700 million. That's the backstory of this case. The only question before the Supreme Court is, should these cases be heard in federal as opposed to state court? So a purely procedural issue, right? But one with enormous consequences.
The 6 Louisiana parishes sued in 2013, but yet only one case has gone to trial in all that time?
That's right. And, you know, that is right out of the oil company's playbook. We've seen it in the climate cases as well, which is delay, delay, delay. Throw up roadblocks, argue every kind of procedural motion you can to keep the case first from going to trial, getting to a jury, and then now after all these years and after all the time and effort spent to win a jury verdict, now the oil companies go to the U.S. Supreme Court saying, save our butts, because we've lost big time. We fought, you know, in the state court, and we lost, and now we want to set aside that loss and start all over again.
And if the Supreme Court rules in favor of the oil companies, that $745 million verdict delivered after a 3-week trial could be thrown out. But the merits of the cases are not before the court.
that question doesn't even get raised. Are they responsible? That's the fiendishly complicated aspect of a case like this, right? The merits don't count. It's all about which court to hear the merits. After there have been years of litigation in state court, a jury verdict against them, now they want to start the clock all over again. It's outrageous, but it is the law. I mean, the law of removal of cases from state court to federal court, that's well-established law. This is a real extension of that law.
And the key issue before the Supreme Court is an amendment to the federal officer removal statute, a law that gives federal courts jurisdiction over civil cases that concern the actions of federal officials or those acting under the orders of a federal official.
That was the focus of the oral argument. And in that statute, in Congress's inimitable fashion, they dropped this phrase relating to. So that's the focus of the case. Was the activity of producing oil and gas in the coastal zone of Louisiana related to the federal contracts that these companies and their predecessors had during World War II? This goes all the way back to the 40s. So the question is, the government contracted with these companies to refine fuel for the war effort. And what the companies are now arguing is, well, in order to refine the fuel, we have to produce the fuel. So the oil and gas production activities that are destroying Louisiana's wetlands are related to our contract to produce fuel for the war effort. That is the key fact in this case. Is that enough to prove that refining oil is related to producing oil? That may be a bit of an oversimplification, but that's the essence of it.
And how does the state of Louisiana interpret those words relating to?
The state says the two activities are separate. And if you think about this, what was the reason that Congress had for requiring removal of cases from state court to federal court? And the logic of it is, if a company, these oil companies, have become an agent of the federal government, doing the government's bidding, then they should be insulated to some extent from being subject to liability in state court. That's the kind of issue that should be litigated in federal court, because the companies are acting as agents of the federal government.
I mean, isn't this also about what they're doing now? So how can this depend on something that happened in World War II?
That's true, and that is one of the arguments Louisiana is making, of course, that this has been going on for decades and continues today. So it has nothing to do with World War II. But if there's logic in this, it's that once an agent, always an agent. I don't buy that. I'm just saying their argument to the court is, everything that we have been doing relates to, in the broadest possible sense, relates to these original contracts which carry forward to today. I don't think the court is going to buy this, but we always have to say, but they might. It sounded to me like at the oral argument, questions coming from Thomas, Gorsuch, the Chief Justice, questions that were harder to read from Kavanaugh, Barrett. Even Justice Jackson was saying at one point to the oil companies, your argument has some weight. That surprised me. So these procedural questions could go either way. But it looks to me and sounds to me like the court is going to deny the company's argument that these cases should have been brought in federal court and have to be relitigated in federal court.
And the state of Louisiana only needs 4 votes to win, because Justice Samuel Alito recused himself from the case due to a stock conflict tied to ConocoPhillips. And so 4 votes would leave in place the lower court decision, the Fifth Circuit decision, which ruled that the cases belong in state court.
Correct. That's a very good point. And I could easily count 4 votes, if not 5, to deny the oil companies.
Pat, let's discuss having a trial in state court versus federal court. Here's Paul Clement, the former U.S. Solicitor General who represents Chevron.
And so for, really since almost the framing of the country, there's been this problem, this issue, this concern with issues that are nationally important but locally unpopular.
He also had other arguments, for example, that if the state can prove their case in federal court, then everyone's going to accept the outcome rather than seeing it as a product of local prejudice. Do you agree with that?
No, that is a stunning indictment of state jury. I mean, that stands the principle of federalism on its head. To suggest the oil companies can't get a fair trial in Louisiana? Are you kidding me? With all of the dependence of Louisiana on oil and gas production? No, it's the case that the damage that the oil companies are doing have reached a point where it's intolerable for these communities to just continue to absorb it. That's what this case is about. And the pushback to his argument is, don't you want the communities that are closest to the impacts, living with the impacts, and in the state where the expertise of the legal questions involved, namely, what does Louisiana law require? Have the companies violated that law? Have they done so deliberately over a continuous period of time? Have they done so knowingly? All of those kinds of questions are state law questions. They rely on the expertise within the state of Louisiana, in the academic institutions that have studied these problems, in the witnesses that would be called, and so forth. Fact witnesses as well as expert witnesses. To suggest that the oil companies should not be held accountable in the state courts where they're doing business and doing this damage is unbelievable.
Several justices also expressed concerns about the broader implications of a decision here on things like employment disputes or a suit against an airline manufacturer that has contracts with the U.S.
This business of indicting state courts and state juries sweeps incredibly broadly, as well as their argument that anything that's related to their original contracts from 50 or 60 years ago is covered by them. Both of these arguments are incredibly sweeping, and that's why the Chief Justice picked up on the butterfly effect. So it would be very surprising, I think, for the court to go that far and buy into this premise that you can't trust state courts.
Thanks so much, Pat. That's Professor Pat Parenteau of the Vermont Law Graduate School. Coming up, can ICE officers be sued? I'm June Grasso, and this is Bloomberg. Demonstrations have become common in Minneapolis since an ICE officer shot Renee Good last Wednesday. On the day that Good was killed, Vice President J.D. Vance held a news conference and declared with certainty that the ICE officer would face no consequences for his actions.
You have a federal law enforcement official engaging in federal law enforcement action. That's a federal issue. That guy is protected by absolute immunity. He was doing his job.
That's a message that's been reinforced by others in the Trump administration. In fact, on Tuesday, the Department of Homeland Security posted a clip of White House Deputy Chief of Staff Stephen Miller amplifying that message.
To all ICE officers, you have federal immunity in the conduct of your duties. And anybody who lays a hand on you or tries to stop you or tries to obstruct you is committing a felony. You have immunity to perform your duties, and no one, no city official, no state official, no illegal alien, no leftist agitator or domestic insurrectionist can prevent you from fulfilling your legal obligations and duties.
So are they right? Will ICE officer Jonathan Ross face any consequences for killing the mother of three? Joining me to answer that question is Anya Bidwell, a senior attorney at the Institute for Justice. Anya, are these Trump administration officials right? Do these ICE officers have absolute immunity?
I hate to say that they are right, but unfortunately, they are very close to being right. And there are exceedingly fewer routes to sue federal officials. It's been happening for a long time. It's not just a Trump administration invention, but what they're doing now is really exposing this gap in accountability between state and local officials. For example, Derek Chauvin, who murdered George Floyd, and federal officials like those ICE agents. So previous administrations didn't like to advertise that. The Biden administration, the first Trump administration, the Bush administration, the Obama administration, they weren't going around and talking about absolute immunity. This administration is happy to talk about it because they want to encourage ICE to go out there, to not care about repercussions, to not de-escalate. And so they're telling them, just so you guys know, there is nothing that can be done to you. There are, of course, some routes.
It appears clear that the federal government is not going to prosecute this ICE officer. But in theory, what about a state prosecution?
Now, the federal government, if it wanted to, could prosecute those officers. But does anybody here really believe that the federal government is actually going to do that? Instead of investigating Jonathan Ross, they are investigating the wife of Renee Good, right? So we are not counting on the federal government to step in here, the one meaningful mechanism. And when it comes to state prosecutions, there's another complication and another immunity that comes in. So states, generally speaking, cannot prosecute federal officials when federal officials are exercising their federal duties. So again, the federal government doesn't even feel compelled to cooperate with the state government in this situation, doesn't even feel compelled to share the evidence because they also know that the state itself is really fundamentally unable to prosecute a federal officer. So that's where we are right now. And J.D. Vance and Stephen Miller are very comfortable going out there and telling ICE, you guys are good. There's nothing really that plaintiffs can do right now.
So Minnesota, they're going to try to do an investigation, right? I mean, is there a way, even if it's a loser way, is there a way for Minnesota to prosecute that ICE officer criminally?
I would try. Again, if I'm a state, what I'm going to try to do at this point is, I'm going to work to pass a statute to allow suits for violations of federal constitution in my courts. And also, I'm going to try to prosecute the officer. Now, immediately there will be a motion to dismiss filed. There will be arguments against it, but at least you are trying to get out there and try to do something. I would also try to just publicly even say, here's what we want to see, right? Some of it is public engagement. When you are a state, if we were to investigate, this is what we would want to see. These are the kind of things that would allow us to evaluate what took place here. Federal government, are you doing this or are you not doing this? States certainly can't just sit there and do nothing, but it's an uphill battle all the way.
Renee Good's family has hired attorneys already, so let's turn to the possibility of a civil lawsuit for damages. First, probably the impossible, suing the ICE officer directly.
Yes, that is impossible because they are ICE agents. And even in general with any federal official, it's extremely difficult. So at the root of the problem is really congressional omission. After the Civil War, Congress passed a statute called Section 1983 to allow suits for the violation of the United States Constitution against state and local officials who essentially weren't complying with Reconstruction and violating people's constitutional rights. At the time, you could sue federal government in state courts, and there was no fear that state courts would be easy on federal officials. If anything, state courts at the time were hostile to federal officials. So Congress wasn't worried about federal officials not getting proper treatment in state courts. So they didn't include them in this statute. They only included state and local officials. And that omission is now used by the Supreme Court as an excuse to deny any access to courts to plaintiffs whose violations happen to be conducted by federal officials. They're saying Section 1983 does not have federal officials in there. There isn't an analog like that for federal officials. And they say Congress should amend that statute, include federal officials in there, and then we will have no problem opening the courthouse doors. Now, on the other hand, there is a problem that circuit courts are interpreting another statute that Congress passed as prohibiting suits against federal officials in state courts too. So that traditional remedy I told you about is also unavailable. So the way that the law stands today is that you turn to federal courts and the Supreme Court is telling you, you guys are not part of Section 1983. We can't do anything about it. And you go to state courts and they're basically saying, well, circuit courts so far have said that cases in state courts are unavailable. Though we do think that by far the best option right now is actually for states to pass their own statutes like that Section 1983 that Congress passed back in the day. And we as public interest lawyers, we have a really good argument to explain to the Supreme Court why that kind of route actually should be available.
Let's just say you could sue a federal officer. The federal officer would probably be indemnified, right, by the government? I mean, they wouldn't have to pay out of their own pocket anyway.
Yes, that's what invariably happens, and it happens with state and local officials as well, that they have indemnification provisions and the governments invariably indemnify them. But at least then the officer is called out, his actions are analyzed, the family gets some answers about what happened, because these days they don't even feel like they need to explain themselves. And then that officer is on notice because he did cost money to the agency, right? So there is some sort of accountability going forward too. And the agencies are much more careful about how they hire because they know that problematic officers are going to cost them a lot of money. And in some situations, when the violations are outrageous, then the government basically says, you're on your own, we're not going to cover it. It all depends. But fundamentally, the important thing is that if you allow families to sue, then they don't carry the burden of the constitutional violation, right? That they are actually able to take control of the situation and get to discovery and have the jury determine what happened.
Finally, let's talk about an option that is available, a lawsuit against the federal government. So the family suing ICE or the Department of Homeland Security.
Yes, that is the best route, even though it is riddled with complexity, as the lawyer who is representing Renee Good's family explained. It is riddled with complexity. It is not a really full vindication of anyone's rights, but it is the best route to accountability the way the law works now. You file a claim under the Federal Tort Claims Act, not against the officer who killed you or who hurt you, but against the United States government. The statute originally was really intended for things like, a USPS driver running over somebody, like a negligence type of an act. And then somebody would file a claim with the agency and the agency would compensate for that negligent action. The statute is not a great fit for constitutional violations like these. And the problem with the statute, too, is that the government invariably invokes the so-called discretionary function immunity. So they basically say the officer was acting within the scope of his duty and he was exercising discretion in that he was making a choice between whether to turn right or left. And therefore, discretionary immunity applies, and even the federal government cannot be held accountable. So those suits are very hard, but it's still the best option, the FTCA route, against the government itself.
Can you think of a big case recently or, the last case where plaintiffs won using that route?
That's a great question. There are no immediate cases that come to mind. What comes to my mind is actually the case we argued in front of the Supreme Court just last year, where there was a wrong house raid on an innocent family's home pre-dawn, even though there was an address on the mailbox right there in front of the house telling the officers that this was a wrong house to raid. And so the family sued the government for this wrong house raid. It was in Atlanta, Georgia. And the government basically argued you can't sue us because the officer exercised judgment and there is supremacy clause immunity and discretionary function immunity. And the case went all the way to the Supreme Court. And Justice Gorsuch even said, you'd think there would be a remedy, wouldn't you, for that kind of a raid? But he said, the answer is not that simple. And the Supreme Court did not rule for the family. They remanded the case back for reconsideration. So this is pretty much like the most positive outcome is that we get to re-argue this case again years and years after this actual wrong house raid, and the family still has seen no justice. The problem then is that not too many lawyers even want to argue these cases because it takes years and years to get anywhere, as this example demonstrates.
Yeah, I remember that case because the facts were so outrageous. Thanks so much for joining me, Anya. That's Anya Bidwell of the Institute for Justice. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.